All right, so good evening, everyone. This is a review slash tribute to the life of Justice Ruth Bader Ginsburg, who passed away last week. Justice Ginsburg was kind of a hero of mine and one of the reasons I went to law school. So I decided to get together and just do this. Thank you for anyone that showed up. My students that are here now, do let your classmates know that this will be recorded. I'm going to give it to our director of communications at gshed, where you can get it anywhere. But thank you for showing up. There's so much going on, just not today, but in America right now, that the hour you decide to spend with someone in and of itself is precious. So thank you for being here as we go along to do this. All right. So Justice Ginsburg, thank you for that. Was born in Brooklyn, where I grew up, was not born, March 15th, 1933. She graduated first in her class at Columbia. She actually started off at Harvard Law, one of only 9 women that were allowed to be at Harvard that year. I say allowed because at her first meeting with the dean of Harvard, he asked all 9 women in a dinner that was supposed to be at their honor to stand up and explain why they had taken the seat of a man. So, imagine if that's how your grad school experience started off. The reason she didn't finish at Harvard was because her husband Marty had graduated before her and had got a job in New York City. So she transferred to Columbia, where she then graduated from. We know her because she is or was a civil rights attorney, arguing many cases before the Supreme Court before she was appointed a judge or a justice. In 1980, she was appointed to the Circuit Court, which for my students is the court right below the Supreme Court. We haven't dived into that yet. And then in 1993, about 5 years after I was born, she was appointed by President Bill Clinton to replace Justice Byron White on the Supreme Court. I point out that her confirmation, as we're going to go into what was going to be a crazy confirmation battle over the next couple of weeks, was 96-3. So whatever people might say about her now, 96-3, she was confirmed. And Justice Scalia, who took the court, took his place in the court only a couple of years before Justice Ginsburg, was also confirmed by numbers as well. So we definitely living in what I would say is a different time. So what I want to do is I want to focus most of this presentation on your questions, your concerns, and your comments, but I did want to have some time to review 5 cases that I thought sort of illustrated Justice Ginsburg's impact on education law, higher education law. Most of these cases will be sort of at the transition between K through 12 and higher education. There's one non-education case, if you'll excuse my indulgence, which is Shelby versus Holder, and we'll talk about that at the end because that is the case which sprung off this whole notorious RBG sort of meme on the internet, and I'll explain that when we get there. So the first case, 2 years in, is a classic Ginsburg dissent called Missouri versus Jenkins. Missouri versus Jenkins had to do with a case in which the Kansas City, Missouri School District had essentially been declared as a segregation district. The court had struggled at times to figure out how to desegregate it, and a court had decided that they were going to order that the salaries of the teachers in that district be increased and the facilities be updated. It got to the Supreme Court on the question not of whether the district was segregated, but whether a court could order Missouri as a state to pay and fund these salary increases. Missouri said, we're not against desegregation, we just can't pay for it. And this is what you will see in 1995, the kind of backward legacy of the 1954 decision, Brown versus Board of Ed, and its successor, the 1955 decision, so almost 40 years to this year, of Brown 2. Brown versus Board of Ed, of course, said separate but equal was unconstitutional. Black children must be allowed to go to school with white children. But the question in 1955 in Brown 2 was how? How should we do it? And rather than actually laying anything down, the same court that decided Brown said with all deliberate speed. The court would go on to find no fundamental right for a student to get an education and no fundamental right for a suburb and an urban district to have to cooperate to defeat segregation. So what you have here are 5 justices of the court agreeing with the state that basically they should not be forced to spend money to actually enact K through 12 desegregation. And Justice Ginsburg dissented. And I'll read her words here. It says, "Today, the court declares illegitimate the goal of attracting non-minority students to the Kansas City School District, and thus stops the district court's effort to integrate a school district that was in 1984 to 1985 school year, just 10 years from this case, sorely in need, and 68.3% Black. Given the deep, illustrious history of segregation in Missouri, to curtail desegregation at this time in this manner is an action at once too swift and too soon." And this will show you, one, Justice Ginsburg attention to history, as she calls out the history of segregation in Missouri, and her attention to the real world problems. I think the court and the conservatives that were in the 5 that decided this court decided basically on theory. The theory that if the federal government were to force a state to do something like that, it would be big government forcing and the theory of states' rights. And Justice Ginsburg said, well, no, what about the students that are getting this unfair and unequal education? And that will become a theme in her jurisprudence, sort of people over process, people over theory. Next, I'll probably do what is her most famous case, not just in higher education, but the case she's really known for in general, and that's United States versus Virginia, which is 1996, about 3 years after she had been on the court. You see, the court really was talking, as a whole here, 7-1 decision, Justice Ginsburg's best friend and opera buddy, Antonin Scalia, being the only one to dissent. Justice Clarence Thomas' son was a member of the Virginia Military Institute at the time, and thus he did not participate in this decision. He probably would have went with Justice Scalia. So maybe it would have been 7-2, but we don't know. In this, what we had was the Virginia Military Institute, what, if those of you that don't know, up until 1996 was the last public school which did not allow women. And the reason it did not allow women, it said, well, our specific type of education is only geared towards men, and only men can do it. And in the 7-1 decision, and the only majority I'll talk about today, Justice Ginsburg disagreed. And in that case, she said, "The notion that admissions of a woman would downgrade VMI's stature, destroy the adversative, that's a lawyer word, system, and with it, even the school, is a judgment hardly proven and a prediction hardly different from other self-fulfilling prophecies once routinely used to deny rights or opportunities. Women's successful entry into the federal military academies and their participation in the nation's military forces indicate that Virginia's fears, for VMI's future may not be solidly grounded. The Commonwealth's justification for excluding all women from a citizen soldier training, for which some are qualified in any event, does not rank as exceedingly persuasive." And Justice Ginsburg wrote law at this point, almost ticking up to my students that read about the layers of scrutiny this week. You probably read about strict scrutiny, intermediate scrutiny, and rational basis. So the question is, where did exceedingly persuasive come from? It came from the mind of Justice Ginsburg, somewhere between strict and somewhere above intermediate. And in this, VMI had to allow women. Almost done here if you have any questions, but got about 2 or 3 to keep going. The next case I decided to highlight was Board of Education versus Earls. And this is a case to my students that we won't actually read, but when we do cover what I call the recreational marijuana revolution in legal problems, we will cover the issues of this case, if not the case specifically. It is in your textbook, and I hope you're doing those readings. Board of Education versus Earls was a case in which the United States upheld the constitutionality of mandatory drug testing by public school students participating in extracurricular activities. So, of course, drug testing is allowed, particularly for minors who shouldn't be using drugs anyway. But in this case, we had a school district in Oklahoma that actually made it mandatory and a condition of participating in extracurricular activities that the student automatically and in all cases decide to be tested, meaning that if you wanted to play high school soccer, if you wanted to play high school football, you had to go through a semester to semester, semester to semester mandatory drug testing. The court upheld this rule in a 5-4 decision, basically stating that because participation in high school extracurricular activities is not a right, that the school doesn't have to give it to you and can decide the conditions for it. However, mandatory drug testing would in most instances violate our rights against unreasonable searches and seizures. The court, if you come for a parking ticket, can't say, well, okay, Kelvin, or okay, Chelsea, your parking ticket case is on Friday, and in order to enter the court, you need to have a mandatory drug test on Thursday. Typically, we need to have some type of reasonable suspicion in order to test anyone. The courts usually hold that students have the same rights as non-students or as adults if the students are minors, unless whatever they're asking for is being disruptive. And here it clearly is not. The court went the other way, and in her typical dissent, here's what Justice Ginsburg said. The court permits a school with a problem its superintendent repeatedly described as not major to test the urine of an academic team member. So the particular, it wasn't just footballs, it was soccer, it was also chess. It was also debate. It was, I guess, I don't know why they were doing that, but they were. Solely by reason of her participation in a non-athletic, competitive extracurricular activity. Participation associated with neither special dangers nor particular predilections for drug use. The legality of the search of a student would depend solely on the reasonableness of the search. Although special needs inhere in the public school context, those needs are not so expansive or so malleable as to render reasonable any program of drug testing a school district elects to install. The particular testing program upheld today is not reasonable. It is capricious, even persuasive. Petitioner's policy targets for testing a student population, students that participate in non-academic, in addition to academic activities, least likely to be at risk for illicit drug use. I guess that's Justice Ginsburg's opinion of the nerds. From illicit drug use and their damaging effects, therefore I dissent. The United States Supreme Court case of Board of Education versus Earls has not been overturned. So the rule right now is a high school can condition participation in extracurricular activities on drug testing, even if they have no reasonable suspicion that their students are doing drugs. The final higher education case is a famous one. We call this Fisher 1, Dr. Stone of your proud alma mater, the University of Texas. Of course, we have two cases, Fisher 1 and Fisher 2. Fisher 1 is actually the least impactful case, but this is one of my most famous Justice Ginsburg quotes, so I decided to give it to you here. Of course, not to ruin the week we'll spend on affirmative action to my legal problem students, but this has to do with the case of a white woman, Abigail Fisher, who was denied entrance to the University of Texas. Texas was using a top 10% plan at the time, so anyone who graduated in the top 10% of public schools got to go to the University of Texas of their choice, the most popular one being at Austin. After that, so we have the top 10% as well as the affirmative action plan. Abigail Fisher said that the reason she had been denied was because of her race being white. Or at least she would have got in over less qualified African Americans had we not been using affirmative action. Completely ignoring that the number of so-called less qualified, if you use test scores as a qualification, number of white students with less qualifications that had gotten in were almost double the number of students of color with less qualifications, again, if we're using test scores that had gotten in that year. Marked hypocrisy, but I won't deviate, especially since it's being recorded. The university Justice Ginsburg wrote a dissent. She actually was one of the only justices to dissent from the holding, because the holding of the first Fisher case, as my students will learn or have already known, was not really a substantive holding. They sent it back to the lower courts, and that's why we got Fisher 2. But in that long dissent, Justice Ginsburg laid it out like this. The university has steered clear of a quota system like the one struck down in Bakke, which excluded all non-minority candidates from completion for a fixed number of seats. And like so many educational institutions across the nation, the university has taken care to follow the model approved by the court in Grota versus Bollinger. Petitioner urges that the Texas Top 10% plan and race-blind holistic review of each application achieve diversity. So, one or two minoritized students apparently are enough, is what Fisher was arguing in this case. So the university must be content with those alternatives and not use race. To add on to that, I have said before, and I reiterate here, that only an ostrich could regard the supposedly race-neutral alternatives as race unconscious. And I have used that quote from Justice Ginsburg time and time again in my own writing. Last case, and then when we can wrap this up and get to your questions, your concerns, your comments, or your questions on the process to replace Ruth Bader Ginsburg. And this is the only non sort of higher ed case that I decided to illustrate today. And I did it because it's an extremely important one and a poignant one, and it does explain her rise as a notorious RBG. So this is Shelby versus Holder. Long history here. But back when we had race riots, no, I'm not talking about 6 months ago. I'm talking about in the 1960s. Justice Lyndon Baines Johnson got together and pushed through the Voting Rights Act of 1965 to ensure that African Americans in the South, and quite frankly, other places in America, could vote without discrimination. The Voting Rights Act, in this case of Shelby versus Holder, was a challenge to two parts of the Voting Rights Act. Section 5, which requires certain states and localities to obtain pre-clearance before implementing any changes to their voting laws. And Section 4B, which contains the formula to determine which of the states had to do pre-clearance. The court struck down Section 4, leaving Section 5 in place, but without a formula to determine which states qualify under Section 5. Section 5 has been gutted as well. There's been a movement since the death of my dear fraternity brother, Kelvin, our dear fraternity brother, John Lewis, to pass the John Lewis Act, which restores Section 4B. But in this climate, it had, like many things, it hasn't really taken aim. In her very vital dissent, some on the right said angry, some on the left said poignant. This was Justice Ginsburg's words. Leaping to resolve Shelby versus County's facial challenge without considering whether an application of the Voting Rights Act of VRA to Shelby County is constitutional, or even addressing the Voting Rights Act severability provision, a little bit of legal ball game in there, but basically, could the act survive without 4B? They didn't even address that. They literally just struck down the pre-clearance formula. The court can hardly be described as an exemplar of restrained and moderate decision-making. This is Justice Ginsburg in conversation with her conservative colleagues, who often accuse the liberals of legislating from the bench, and they often say that judges should be restrained and moderate. This was all anything but a restrained and moderate decision. And here is the quote: hubris is a fit word for today's demolition of the Voting Rights Act. And this was the line that got RBG memes on the internet, a rap song to one of, in my opinion, the greatest rapper of all time, Biggie's verses. And she embraced, as someone who came from Brooklyn herself, the notorious RBG model. Hopefully, as we go into an election year, people are voting. We know the type of voter suppression that has already impacted and will impact. Hopefully one day, in the name of John Lewis, we can get a restoration of Section 4B of the Voting Rights Act. So, Justice Ginsburg was 87 years old, spent more than 30 years on the bench, and I can say, as a lawyer and as someone that studies her work, she will surely be missed. So what now? Well, my students know that I go to the language. Article 2, Section 2, Clause 2 of the Constitution says nothing but this. He shall have the power, blah, 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 and by and with advice and consent of the Senate shall appoint judges of the Supreme Court. It also gives them power to appoint ministers, councils, ambassadors. But here it is, folks. This is it. This is the only constitutional language we have. No other laws are passed on this. I will say, and I won't necessarily address it now, I might address it in the questions, that what Article 2, which outlines our court, also in the Constitution, which outlines our power, is absent about, is the number of justices on the court. It's 9 because we have it as 9. If a Congress, who is its own co-equal branch, wanted to change that, they could. But as far as what the constitutional mandate is, the constitutional mandate is that the president, and I said, and by and with the advice of the Senate, shall appoint. It's not may, it's shall. So anyone that is a careful legal observer would say that it is the president's legal obligation to appoint a justice for the Supreme Court, and it's the legal obligation of the Senate to advise and consent. So why is this controversial? Well, we had a similar situation. Justice Ginsburg's best friend, but opposite on the court as far as ideology, died right around Valentine's Day. I remember it like it was yesterday because I was writing my dissertation at the time and had to take the entire week off because it was a bombshell. Justice Scalia died in February, and an election was coming up in November. So what did and this is just one example of what I'm calling judicial hypocrisy on the part of our conservative party today. Chuck Grassley, who was the chairman of the Judiciary Committee at the time, said, it has been the standard practice over the last nearly 80 years that Supreme Court nominees are not nominated and confirmed during presidential election years. First of all, that's just not true, but let's take Chuck Grassley as his word. Okay. Given the huge divide in this country and the fact that the then President Obama, above all, has made no bones about his goal to use the courts to circumvent Congress, in his opinion, and push through his own agenda, it only makes sense that we defer to the American people who will elect a new president and select the next Supreme Court justice. And as you can see on the right side of the screen, Chuck Grassley in 2020 seems to disagree extremely with Chuck Grassley in 2016. So, folks, that's all I got for you today. I'm going to turn the recording off now. Thank you for all who are viewing this later, and I'm more than willing to take questions and comments via email if you wish. But now I will turn to questions for